In this video, we're going to take a look at the EC Regulation 330/2010, also known as the Vertical Block Exemption Regulation. So let me first start by pointing out some of the issues regarding the scope of Article 101, Paragraph 1, and how they relate to Article 101, Paragraph 3, that is the exemption provision. Now, as we know, Article 101 sets out a prohibition in paragraph 1, and this prohibition involves restrictions of competition either by object or effect. So in this large circle, we have the scope of the prohibition represented within the circle. Now, within that circle, some agreements or some restrictions meet the requirements of Article 101.3. In that case, these agreements will qualify for exemption under Article 101.3, again, as long as the cumulative requirements of Article 101.3 are met by that agreement or restrictive clause. Now, what the block exemption does is it sets out a number of requirements, and if these requirements are met, the requirements set in the Vertical Block Exemption Regulation, for instance, if they are met, then the agreements covered by the block exemption will be automatically exempt from Article 101.3. So in this case, we have a narrower circle depicting the type of agreements that would fall under the block exemption. So in order to assess if these requirements are met, the requirements of Article 101.3, as we know, this involves a self-assessment conducted by the firms that are party to the agreement. Now, because of the existence of these block exemption regulations, sort of the first question to ask is, okay, if it is covered by the prohibition, is it then within the scope of a block exemption regulation? And if it is, then the agreement is oped legis compatible with Article 101, Paragraph 3, and thus it is not incompatible with Article 101, it's not incompatible with the treaty. Now, again, this will involve the conduct of self-assessment in order to ascertain whether or not the agreement is covered by this block exemption. Okay, so there are a number of block exemption regulations. In this video, I will focus only on Regulation 330/2010, which serves as an example as to the structure and the way that these other regulations are applied. But as you can see, there are other regulations like the car distribution regulation. There's a block exemption covering technology transfer agreements. There are 2 block exemption regulations covering R&D agreements and specialization agreements. And there are also sector-specific block exemption regulations, one covering insurance and the other covering air transport. So let's take a look at the vertical restraints block regulation. So in order to understand how this regulation applies, the first point has to deal with scope. So all vertical agreements are covered by this regulation, and you have here the definition given in Article 1, Paragraph 1, Proviso A. So an agreement or concerted practice that is entered into between 2 or more undertakings, each of which operates for the purposes of the agreement or concerted practice at a different level of the production or distribution chain. And the agreement relates to the conditions under which the parties may purchase, sell, or resell certain goods or services. Now, the exemption means that all the vertical agreements covered by the Vertical Block Exemption Regulation are then excluded from the scope of the prohibition of Article 101, Paragraph 1, on the grounds of Article 101.3, as we've seen in earlier slides. Now, in order to meet these requirements, the agreement must involve parties that do not have shares above the market share threshold of 30%. So neither the buyer nor the seller may have in their respective markets more than 30% of market share. If they do, then the block exemption regulation will not be applicable to the agreement between those firms. Secondly, the agreement must not contain any so-called hardcore restraints, and these are set out in Article 4. So even if the agreement is below the market share threshold of 30%, if the agreement contains a hardcore restraint, then the agreement will not be eligible for exemption under the Vertical Block Exemption Regulation. Okay, so why do we have this market share threshold? Well, mostly because economic theory indicates that vertical restraints will be more likely to have anti-competitive effects when at least one of the parties to the agreement, either the buyer or the seller, has market power, that is to say, the power to raise prices above the competitive level or to reduce production below the competitive level. So, in a sense, what you have is that this market share threshold means that the agreement will be presumed to meet the requirements of Article 101(3) as long as it does not include hardcore restrictions and provided the market share does not exceed 30%. Well, but what happens if the market share of one of the parties is above 30%? Well, in that case, as provided in Recital 9 of the regulation, there is no presumption of illegality under Article 101, paragraph 1, but there's also no presumption that the requirement does not meet the requirements of Article 101(3). So, in other words, you will need to conduct an individual assessment as to whether or not the agreement is both caught by Article 101, paragraph 1, and if so, whether or not it meets the requirements of Article 101(3). So, being above the market share threshold of 30% does not presume illegality. It merely means that you have to conduct an ad hoc analysis of the facts of a given case. Do note, however, that under the rules of the block exemption regulation, the exemption may still be withdrawn by either an individual decision or by a commission regulation, even if the agreement is below the 30% market share threshold. Now, let's take a look at hardcore restrictions. As I said, Article 4 includes or describes these hardcore restrictions, and these hardcore restrictions, any one of them, will make the Vertical Block Exemption Regulation inapplicable to that agreement. Now, first and foremost, we have so-called resale price maintenance. That is to say, fixing a minimum or a fixed price for goods. If the manufacturer agrees with the distributor that the distributor may not sell below a given price, that is one of those hardcore restrictions, also known as resale price maintenance. Now, this does not include simple price recommendations. If the supplier merely recommends that the distributor price good X at a price of 5 euros, but then the distributor is free to charge a price either below or above that level, then this is not a hardcore restriction, and so it will not be deemed to lead to the inapplicability of the regulation. The fixing of a maximum price, so the reseller, for instance, may not sell above the price of 5 euros, is also not a hardcore restriction. The rationale here is that it is in the interest of the supplier to increase sales, and so even if it is in the interest of the dealer to reduce sales because the dealer has market power at the distribution level, at the retail level, then a provision whereby a maximum price is fixed actually controls and eliminates market power on behalf of the retailer, which is in the interest of the supplier to maximize output. The second type of hardcore restrictions have to deal with territorial and customer restraints. Now, here the regulation uses an odd legislative technique whereby these territorial and customer restraints are deemed to be hardcore restraints. However, there's a list of restraints that will still be allowed, even though these form part of this set of territorial and customer restraints. So, as an example, restrictions on active sales in the exclusive territory or to a reserved group of customers, either reserved to the supplier or to another distributor. This is not a hardcore restriction. The logic being that in this case the supplier is affording protection, which covers the necessary incentives either for itself or for another exclusive distributor to promote sales in their territory. Restrictions of sales to final clients by wholesalers may also be enforced, as well as restrictions in the context of selective distribution systems to make sure that distributors that do not meet the selective distribution requirements do not obtain these goods. And finally, restrictions of sales of components as spare parts. Now, Article 5 deals with the so-called grey list, that is to say, excluded restrictions. These excluded restrictions are deemed to be restrictions of competition, and so they do not benefit from the exemption. So they are excluded from the scope of the regulation. So again, with an agreement that is below the 30% market share, the presence of one of these restrictions will not lead to the agreement losing the benefit of the block exemption, but that specific restriction will not be covered by the block exemption. And so it may be found either by the Commission or a national competition authority to be a restriction of competition. So here we find non-compete obligations either of an indefinite duration or that exceed for a delay that exceeds a period of 5 years. So non-complete obligations include the obligation by a distributor not to sell goods that compete with the goods supplied by a given supplier. Obligations that cause the buyer not to manufacture, purchase, sell, or resell goods or services upon termination of the agreement is also excluded. And finally, obligations that prevent the members of a selective distribution system from selling the brands of particular competing suppliers. So again, in this context, a lot the same logic of non-compete obligations. Now, the Vertical Block Exemption Regulation, like all these block exemption regulations issued by the Commission, is subject to a termination date. Under Article 10, it entered into force in June 1st, 2010, and it will expire on May 31 of 2022. The regulation is currently under review, and there's already a draft new regulation as well as a set of draft guidelines prepared by the Commission. Before the new regulation enters into force, you may consult all these relevant documents in the link provided in this presentation. Now, to conclude this video, let me say a few words on the EC guidelines on vertical restraints. Now, these are far too complex to summarize with any degree of depth in a short video. So let me just talk about the structure of the guidelines, and then we will look at how these guidelines propose a methodology to analyze vertical restraints. Okay, so as a broad guide to the guidelines consist mostly of 3 parts. The first part deals with agreements that fall outside the scope of Article 101, Paragraph 1. This includes some subcontracting agreements as well as agreements, agency agreements, and these are set out in paragraphs 8 to 22. The second part, paragraphs 23 to 95, includes an explanation point by point of the Vertical Block Exemption Regulation. So when you read the regulation, you should have the guidelines with you so that you can consult in sequential order the different concepts and how the Commission interprets the different provisions of the Vertical Block Exemption Regulation. So this is a precious guide that gives you insight into what is the meaning of the provisions of the Regulation 330/2010. Now, as we've seen, you will have many vertical agreements that either because they have hardcore restrictions or because they are entered into by parties that have more than a 30% market share, that will need an individual case-by-case analysis. Now, the final section of the guidelines deals precisely with that. It sets out the principles for the enforcement of Article 101 to agreements not covered by the Vertical Block Exemption Regulation. And so here you will find details as to how the Commission or a national competition authority or a tribunal, a national tribunal, should look at both the market, the possible positive and negative effects of vertical restraints, and whether or not it could be justified under Article 101(3). So moving on to the methodology applied by the Commission, it's important to understand that the main concern for the Commission's approach to vertical restraints deals with the impact that such restraints might have on consumers, rather than the fairness of the relationship between suppliers and distributors. And this can be seen in paragraph 97 of the guidelines, where the Commission clearly states that with regard to restrictions of competition by effect, vertical restrictions will only be deemed to be unlawful where they have an effect on actual or potential competition, such that we can reasonably, with a reasonable degree of probability, we can expect negative effects on prices, output, innovation, the variety, quality of goods and services. Now, if you will recall, if you've read the Société Technique Minière judgment by the European Court of Justice, you will know that this analysis has to be done by comparing the actual or likely future situation on the market with the vertical restraints in force with the situation that would otherwise prevail in the absence of the vertical restraints. And again, you'll find this reference in paragraph 99 of the vertical guidelines. Now, the Commission states a number of possible negative effects, and these amount to sort of the overall theories of harm connected with vertical restraints. The first has to deal with anti-competitive foreclosure of other competitors at one of the parties' levels of the chain of supply. So this could be either at the level of the supplier or the buyer. These risks of foreclosure naturally call into question inter-brand restrictions, that is to say, restrictions between different brands either of suppliers or different brands of, say, chains of distribution in the case of buyers. Secondly, vertical restraints may be used so as to facilitate collusion between competitors at either the seller or the buyer level. And finally, vertical restraints may create obstacles to market integration. And if you've already read Constant Grundig, you will be familiar with the idea behind the prohibition of absolute territorial protection as a restriction of competition by object, which is clearly linked to the goal of market integration. A special reference to branding, that is to say, to branded versus unbranded products, as the Commission states that branded products may enhance negative effects due to the fact that substitutability of the product will be reduced from the perspective of consumers. And that leads to a reduced elasticity of demand and thus to the greater risks of market power. On the other hand, the Commission recognizes that vertical restraints may pursue a number of possible positive effects. These include solving free rider problems and reducing opportunistic behavior. Vertical restraints may be useful to open up or enter new markets. And again, Société Technique Minière is a case where the ECJ back in 1966 highlighted the importance of vertical restraints in order to promote entry to new markets. Something called a certification free rider issue is another possible positive effect. Solving hold-up problems, that has to do with the incentives to either conduct specific investments that are specific to that vertical relation between the supplier and the buyer, and they can occur at either or even both levels of the chain of supply, as well as hold-up problems where there is a transfer of substantial know-how. Then we have vertical externality issues, where vertical integration, either by contract or through merger, may resolve some of these externalities and lead to more efficient markets. Economies of scale in distribution might be another benefit from vertical restraints. Vertical restraints may be required in order to overcome capital market imperfections. And finally, they may be useful in ensuring uniformity and quality standardization. For our final slide, let me just list the specific types of vertical restraints that are analyzed in much more detail by the European Commission guidelines on vertical restraints. So firstly, we have single branding. So this includes, for instance, non-compete obligations. So here you're binding, for instance, a distributor to sell the contractual products supplied by that specific supplier and not goods that would compete with those supplied by that particular supplier. Exclusive distribution, where you appoint an exclusive distributor, exclusive customer allocation, selective distribution, that is to say, only distributors that meet certain specific qualitative criteria may be admitted into the official distribution network of a seller. Franchising agreements, now requiring only 3 paragraphs in the guidelines. Exclusive supply, so the buyer undertakes to buy these products exclusively from a supplier. Upfront access payments, this is something that occurs in the areas where you have large supermarket chains, and the supermarket chains, by exploiting a scarce space, that is to say the store space, may actually require an access payment to suppliers in order for their goods to be present in their shelves. Category management agreements that are also used by large retail chains. Tying, so subordinating the purchase of one good to the acquirer, also obtaining another good that is in a different relevant market. And finally, resale price restraints that I have already mentioned. So in order to go deeper into this, please check the relevant chapters of the vertical guidelines. Okay, and this concludes our video for today.